Thank you so much for joining us today. My name is Jie Huang. I am a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things to go over before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series. We are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you all a copy of the PowerPoint that will be used in this webinar. Second, we will be sending out a visa guide, a comprehensive guide to the visa categories that we will be discussing today that you can use as a reference. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we encourage you to subscribe to our YouTube channel and hit the notification button as we do upload a variety of videos on various immigration law topics. Finally, we will send you a link where you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further in detail. So today we are very lucky to have Kelly Weiner, who is the managing attorney of the firm with a wealth of experience handling cases in all of the visa categories that we will be speaking about today, who will be presenting about the options available to individuals with extraordinary abilities in their fields. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further ado, I will turn it over to Kelly.
Thank you, Jay. Perfect. So we're going to get started today just with a very general overview. What are the extraordinary ability visa categories? So as you can see here, there's kind of 3 that we're going to discuss initially, and then we'll kind of go into more detail on the various slides. So we have the O-1A. So this is a non-immigrant visa for people of extraordinary ability in the sciences, education, business, or athletics. And the standard is someone who is of a very, very small percentage who've risen to the very top of their field. Then we have the O-1B. So this is also a non-immigrant visa. So both the O-1A and O-1B are temporary visas for people who want to come to the United States for a temporary period of time. And the O-1B is for individuals with extraordinary ability in the arts or achievement in motion picture or the television industry. And there's kind of slight distinctions between the standards for each of these. So for the arts, the person must have distinction in their field. So a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered, to the extent the person is described as prominent, leading, or well-known in their field. And then for motion picture or the television industry, you have to show that you've reached a level of acclaim substantially above that of your peers. So you can see here that, between O-1A and O-1B, there are some important distinctions to make, although there's many similarities, as we'll see on a chart on the next slides. It's still good to know, which one would be the category you're going for, because for example, if you're getting an O-1B for the arts, that has a slightly lower standard than if you were going for an O-1A. And there may be some categories that aren't as clear cut, where you arguably could be going for an O-1B under the arts as opposed to business. Certain, industries that are kind of very new, things like, kind of drink mixologists or sometimes, models. Sometimes there's arguments to be made, to apply under the category of O-1B with kind of the lower standard, which can be easier to meet. So always good to keep in mind that although there's many similarities, there are some important differences. Then we'll talk about the EB-1A green card. So this is different from the O-1A and O-1B because this is a permanent ability to stay in the U.S. So if you qualify for an EB-1A, you can live and work in the United States permanently and ultimately even apply to become a U.S. citizen. So for the EB-1A green card, this is for individuals with extraordinary ability in sciences, arts, education, business, or athletics. So this kind of combines, the two that are split out in the O-1A and O-1B. The EB-1A will combine them. And the standard is someone of a small percentage who's risen to the very top of their field of endeavor, can show sustained national or international acclaim, and plans to work in the United States in their field of expertise. So for the EB-1A, as you'll see, kind of some of the criteria, look extremely similar to the O-1A and O-1B. However, because this is a permanent green card that you would be getting, the standard is somewhat higher. So just because you qualified for an O-1A or just because you qualified for an O-1B, that doesn't mean you have an automatic path to approval for an EB-1A. They still, will review the case on its own merits, and you will need to meet kind of that heightened standard for the green card. And then for all three categories, so for the O-1A or an O-1B, you can get these visas initially approvals for 3 years, and then either extensions for 1 year, or if you have a new project, sometimes you can, get another 3 years. And during that time, you need to show you have work in your area of extraordinary ability to cover that whole time. So even though hypothetically, you could apply for, 3 years as the maximum time. If you only have work in your area lined up for 6 months, then that may be the only, you may just get an O-1B for 6 months because they're only going to grant it for that amount of time that you have work lined up. This is a little different for the EB-1A. For the EB-1A, because it's permanent, it's a green card, you just need to you need to kind of provide a statement that explains what you're going to do in the United States, that you plan to continue working in your field of endeavor, and any supplementary documentation you have to support that can also be included. So let's look a little more at the O-1A. So for the O-1A, the basic qualifications are you either have to have received a major internationally recognized award, like a Nobel Prize, a Pulitzer Prize, or much more frequently, people are going to show evidence that they meet at least 3 of the following. So receipt of nationally or internationally recognized prizes or awards, membership in associations in your field, published material in professional or major trade publications about you and your work in the field, original scientific, scholarly, or business-related contributions of major significance, authorship of scholarly articles, a high salary, participation on a panel or individually as a judge of work, employment in a critical or essential capacity for organizations that have a distinguished reputation, or sometimes you can get you can also submit other comparable evidence if your field is the type that does not lend itself easily to these particular criteria. So obviously, 3 is the minimum, but more is going to be better. So if you do meet other criteria, you would also want to, explain, how you, how that demonstrates that you have extraordinary ability. And it's not going to be enough just to show that you meet, that you're a member for example, if you're a lawyer and you're a member of a local bar association and you pay a fee to be a member of that association, that's not going to be good evidence really of membership of associations in your field because of the second part of that, which is the membership in the association has to require an outstanding achievement. So it is very important with the regulations. They are very specific. U.S. Citizenship and Immigration Services pays attention to each word sometimes. There's lots of guidance out there about how they interpret these. So you do want to kind of discuss with your attorney to figure out, which evidence do you want to include? Because some evidence, could actually work against you. It's not necessarily always better to just include every single thing you have because some of it may make your profile look kind of less important than it actually is if you're including lots of things that really aren't demonstrating that you are someone who has risen to the very top of your field. All right, so let's talk about the O-1B. Some similarities here in the structure of the, eligibility. So either you're nominated or won a very significant award, Oscar, an Emmy, a Grammy, or evidence of 3 of the following. And so you can see here when you read through these criteria that they are more focused on the arts, because this category is for the arts or for TV, motion picture industry. So these kind of criteria are all going to be focused around the arts. Again, if there is other comparable evidence, because you're your industry in the arts is kind of one that's, relatively new or is just being defined, you can always try to include those as well. But generally a best practice to try to meet each of these three, as many of these criteria as possible. And it's a similar analysis in terms of just because you have held a performing, just because you've been a lead or a star in a particular role, you also need to look at where did you perform that role? Like what, which, playhouse or theater was putting on this production? Is it one that has a distinguished reputation? Who did you compete with to get this type of role? All of those, all that background context and information is very important. So let's look a little about what the difference is between the O-1A and the O-1B. So as we've discussed, kind of the difference in fields. So O-1A is science, education, business, or athletics. O-1B is arts and motion picture or television industry. The standards, as we've discussed, are somewhat different. So O-1A is going to be a more difficult standard to meet generally than O-1B. So definitely a good thing to keep in mind if you're in one of those categories that might go one way or the other. In terms of how long they can be issued, the initial, approval can be for 3 years with then extensions of 1 year if you're finishing up the same project. Or if you have a new set of projects, then you can get an approval potentially for another 3 years. Although, as I discussed, it's only going to be approved for the amount of time that you can prove you have extraordinary ability work lined up. So this is significant, particularly sometimes in the arts where you may be coming, to put on a series of concerts, and then maybe a few of those concerts get canceled. There are situations where, you may get an approval, and sometimes USCIS will even look up on the internet to see, is this production still going forward? So always good to keep in mind that, when you're coming, for an O-1A or O-1B and you have an agent situation and you're submitting an itinerary, they can certainly question you, if that itinerary changes, particularly if this is something that's kind of publicly available information. They may sometimes come back and question you, particularly when major things are happening in the industry. As we know right now, there's kind of strikes going on, in the arts. So always a good thing to keep in mind that you will need to prove that you have that extraordinary ability work lined up for the full length of time. So can your family come to the US? Yes, they can. So your spouse, and minor unmarried children, under 21 can accompany you. However, they cannot work in the US, although your children could go to school. And then the EB-1A green card. So, the requirements are very similar to the, O-1A or O-1B. So either receipt of a major internationally recognized award or meeting 3 out of 10 criteria, which are kind of aligned with both the arts and, science, business, athletics. So, important thing, and this is for O-1A and O-1B too, but particularly for the EB-1A, is that there's 2 steps to the analysis. So first, they're going to determine, have you met the plain language of the requirement? So, have you, been a judge on a panel, in your industry? And then, they'll say, okay, you've met that. The second step, they're going to consider the quality of the evidence and look at it in totality to make a final determination as to whether this evidence really shows that you are someone who has of a very small percentage who's risen to the very top of your field of expertise. So you always want to be thinking in that direction. Any evidence that you submit, you want to be thinking, what does this demonstrate? Not just, that I'm a member in associations, not just that I've been a judge, for different, competitions in my industry, not just that, a magazine, like Naples Weekly, posted something about me one time. You want to be thinking about, what does this demonstrate, and does this show that I am someone who's risen to the very top of my field? And that's going to be very important in all aspects of your application when you consider what documentation to submit. So now I'm going to turn it over to GA to talk to us about the National Interest Waiver, which could be a great option for people who may also be qualified for the other extraordinary ability visas.
Sure. Thank you, Kelly. So let's talk about the National Interest Waiver. And this is an immigrant visa. So it is an application for a green card. And one thing to note here is that you are allowed to self-petition for qualification under the EB-2 National Interest Waiver category, which can be a very attractive option if you do not have a US-based petitioner to act on your behalf. So let's talk a little bit about how to qualify. So the first step is to qualify under the threshold requirement to be considered under the EB-2 category generally, which is that you must either have an advanced degree or the equivalent of an advanced degree. Now, what does that mean? So advanced degree is defined as a master's degree or above in your field of endeavor, and this includes degrees like JD or MD, for which you already need to have a bachelor's to qualify for admission. You can also meet the master's or equivalent. You can also be considered to have an advanced degree equivalent if you have a bachelor's degree in your field, but if you also have 5 or more years of progressive work experience in your field after you have received your bachelor, sorry. So what does it mean to have 5 or more years of progressive work experience? Progressive work experience means your duties and responsibilities changed over time to include more senior responsibilities, to include more complex duties. This can be shown by either a change of your title, for example, the change of salary, and also a description of how your duties have changed. Now, there is another way you can meet the EB-2 category, and which is through showing that you have exceptional ability in the sciences, arts, or business. And to show that you have exceptional ability, you first need to show that you can produce evidence 3 or more categories of the 7 criteria that is listed here. For example, this includes 10 years of experience in your field, high salary in comparison to others who are in your field, proof of recognition of your achievements in your field by your peers, industry, or government actors, membership in professional associations, and or having a license to practice in your field. So in addition to showing that you can produce evidence under at least 3 of the 7 criteria, qualitatively, the totality of this evidence should show that you do have a degree of expertise that is significantly above what is ordinarily encountered in the field. Now, one thing to note is that the standard here to judge exceptional ability is definitely lower than the standard used for judging EB-1A criteria. For example, the definition of extraordinary ability, which requires someone to be at the very, very top of their field of endeavor. That is certainly not required to meet the exceptional ability threshold criteria. You just need to show that you are operating at a degree significantly above what is ordinarily encountered. Now, let's then move on to, the center of the application, which is showing that you qualify for the National Interest Waiver. And showing that you qualify for the National Interest Waiver is determined through an analysis of 3 factors, which was promulgated by the case called Matter of Danisar. And these are the following factors. The first factor is that the applicant's proposed endeavor must have substantial merit and national importance. The second criteria is that the applicant is well positioned to advance the endeavor. And the third criteria is that, on balance, it must be beneficial to the United States to waive the requirements of a labor certification for that particular applicant. Let's pack that down a little bit. The endeavor has substantial merit and national importance. What does that mean? So the proposed endeavor is basically the applicant's plans in the United States. And what they propose to do in the United States can be in a wide variety of fields, such as business, it can be health, it can be education, it can be science and technology or engineering. And favorable endeavors would include plans such as furthering human knowledge in those key areas through research and development, for example. And some of the examples that the case law talks about is medical advances or civil engineering or improvement of manufacturing processes, for example, that has the potential to further and advance scientific knowledge in a particular field. Now, another way to show substantial merit and national importance is through showing that your endeavors have a potential to result in a strong positive economic impact to the region or to the nation as a whole. And this can also be supported by showing that your business, if you are an entrepreneur, has the potential to generate a high number of U.S. jobs or to spark economic development in a particular region where it is seen as an underdeveloped region, for example. So what the really important question to ask here is, what is the future impact of an applicant's work and how is that important to the United States, right? So strong cases will also bring in evidences such as government reports, and expert letters that describe why certain areas are key to the national interests of the United States. For example, sustainability is one area that there has been a lot of executive orders and lots of investment by the government to advance that area. And so if your particular proposed endeavor has the potential to significantly contribute to those initiatives, that could be a positive factor for your case. Now, how do you show that you're well positioned to advance the endeavor? You can show that in many different ways. Applicants typically show a relevant educational background, professional experience that is related to the project that they are proposing to do. And really what the government is looking for is a record of success in previous related projects that show that this person has the unique skills and experience to really make these plans a reality. And now, what are some strategies on arguing the third prong, which is that on balance, it will benefit the United States to waive the requirements of a labor certification for that particular individual? Sometimes we would take the strategy of emphasizing prong one, showing that there are broad systemic benefits to the field as a whole. That is coming from the proposed endeavor. Sometimes we would emphasize prong two, which is that the individual has particular skills and experiences that cannot easily be replicated by other U.S. workers who are in that field. We can also talk about some special considerations, such as substantial economic benefit to the United States that can be projected from the proposed endeavor, such as job creation and generation of tax revenues, which pose a countervailing benefit to the ordinary benefits of the labor certification requirement, which is supposed to help protect the U.S. labor supply. All right, so we'll move on to the next slide. So we can talk a little bit about expert opinion letters, which is an important element of both the EB-2 NIW green card application and also an important part of the O-1 visa application or the EB-1A extraordinary ability applications. So the purpose for these letters for each type of petition is a little different. So for the EB-1A or the O-1A, for example, you would want the expert letters to confirm that the individual beneficiary has extraordinary ability in the field and is well known in the field to meet the statutory criterion that the person should have sustained national or international acclaim in that field. So the letters for the EB-1A and O-1A petitions, for example, will really focus on what are the achievements that the person has made in the field so far, what are the original contributions that they're well known for. So it will be, looking at the past achievements of that person. For the National Interest Waiver, for the EB-2 National Interest Waiver application, an important part of the letter would really be talking about the prospective impact of the project or the work that the individual is coming in to do, right? So, for example, some letters will talk about the national importance of the plans, and it can really be powerful to have a letter from someone who is affiliated in a government agency or working at a government agency to really confirm that these endeavors are in the national interest. Another type of letters that support an NIW petition could be focused on the well-positioned prong, the second prong, and really talk about what the applicant has done in the past and how it constitutes a record of success in the field that will make them well-positioned to, make these plans a reality. So for example, previous employers can write letters confirming the applicant's leading role in a particular project that resulted in a significant impact to the field. Now, who is writing a letter? It is important to look at the credentials of the individual who is writing the letter. So instead of getting a letter from someone who is at your peer level or lower subordinate position, it is better to get them from your supervisors or from other leading experts in the field who have curriculum vitae, CVs that show decades of experience and stature of being a top expert, such that the letters become more credible to USCIS. How does the individual know you? So for these petitions, we would recommend getting a mix of independent experts and inner circle experts. They serve a little bit of a different purpose here. Inner circle experts are people who have worked with you before, and they can speak in detail about your achievements in the past. While in contrast, independent experts are people who don't know you directly, right? Who haven't directly worked with you before, but they know you through your work or through your reputation in the industry. And these types of independent letters can be powerful because they can be seen as more objective. Those letters can confirm that your abilities are outstanding in the field, and also that you enjoy the reputation in the industry that is required by the regulations. Now, let's then talk a little about the content of those letters, what is important to include in the discussion in those expert letters. Here, one area to note is that specificity is very important, right? And so if the letters are formulaic and simply repeat the regulatory language, it is likely that USCIS may discount them. So for example, instead of just saying applicant is a well-known figure, or just saying the applicant's project has national importance, it is important to develop these details a little further and explain how the applicant is well known, what did the applicant do, and why was this important to the industry. So really building out that narrative. And also for national importance, really kind of expanding out the details here and talking a little bit about what is the limitation in the field that people are seeing. How does the applicant's project promise to improve those limitations, solve those limitations, solve a problem in the field, and what is the potential impact that can come from this work in concrete, on the ground terms that can really help support many aspects of NIW or an O-1 EB-1A petition. All right, so we'll move on to the next slide. Which category should I apply for? So there are a couple of considerations that can affect the decision of which channel to use. So the first question is, do you want to stay in the United States temporarily or permanently, right? So as Kelly mentioned before, the O-1A and O-1B are non-immigrant visas. You can continue to renew them, but you do need to continue to have work, and you do need to continue to apply to renew your visas after the designated time is up. One advantage is that it is faster to get than with EB-1A or NIW green cards, because the green card petition can take a little bit longer to get approved. However, yes, and in addition, if you are if you have the need to travel in and out of the United States frequently, then the O-1A and O-1B can also be a good option because if you get the green card and become a permanent resident of the United States, there are some restrictions on how long you stay in the United States as opposed to staying abroad in order to keep your permanent resident status. So definitely this can be a consideration. So as I mentioned, the EB-1A and NIW are both immigrant visa options. Those will result in the person obtaining a green card, and in these categories you can self-petition for the green card as well, but really these options make sense if your plan is to live and settle in the United States on a permanent basis. The second consideration you want to ask is, do you have a U.S. employer or agent to act as the petitioner, or do you want to self-petition, right? So what does that mean? So for the O-1A and O-1B, for those visas, you do need a U.S. entity or a U.S. agent to act as the petitioner for your case. So for example, what if you are an entrepreneur and what if you own a company in the United States? Well, you can also use an O-1 visa in that situation because the company, which is a U.S. entity, can act as the petitioner. So that is possible because the company itself is considered a separate entity from the individual. Although there could be some pushback too. So definitely talk to an immigration attorney if that is the option you are considering. By contrast, the EB-1A and NIW green card options both allow self-petitioning by the beneficiary applicant. So for those categories, the applicant does not need any pre-existing ties to the United States in order to be able to apply. Now, finally, let's talk a little bit about family considerations. So as Kelly mentioned before, for the O-1A and O-1B visas, spouses and minor children can come to the United States to accompany the principal applicant. However, the spouse beneficiary does not get work authorization through the O-3 visa. The children can study in the United States while they're here. Now, by contrast, one advantage of the EB-1A and NIW options is that spouses and minor children can also apply for green cards as derivative beneficiaries along with the principal, and also can apply for the work and travel authorization if they are applying under the I-485 adjustment of status option. So this can be a great advantage if you would like to give your spouse and children the option to also become green card holders. All right. So then now let's talk a little bit about strategy considerations when you are moving from a non-immigrant visa to a green card. Particularly, so let's talk first about qualifications, right? And as Kelly mentioned earlier, jumping from the O-1A, O-1B visa to an EB-1A green card can actually be quite a significant jump. The EB-1A in particular has very high evaluative standard. So just because you already were approved for an O-1A or O-1B does not mean you automatically qualify for the EB-1A, and there may be a need to really strengthen your profile and accumulate more quality evidence before you may want to try for the EB-1A. And this is because the O-1A and the EB-1A, for example, has very similar language, but they are interpreted very differently on the ground by USCIS officers, just because the EB-1A results in a green card as opposed to a non-immigrant visa. Then now let's talk a little bit about timing issues. So if you have a non-immigrant visa already, and if you are in the United States, strategy could be a good idea to consider when you want to apply for an immigrant visa, right? Because for some categories of non-immigrant visas, non-immigrant intent is judged quite strictly. For example, if you already filed a I-140, which is the underlying petition for an EB-1A or an NIW, this can be interpreted as your expression of immigrant intent. And that may result in some complications when you're trying to renew your non-immigrant visa status, or if you're trying to apply for a new non-immigrant visa status. So for example, let's say you have a TN visa. If you are thinking of renewing your TN visa in the near future, it could be strategically better to renew your TN visa first and then apply for the I-140 under, the EB-1A or EB-2 NIW, for example, to avoid there being any issues with non-immigrant intent. Dual intent visas are not affected by this, such as the H-1B or an L-1. And this can be quite a complicated area to think about. So definitely reach out to an attorney if you are in that situation. So another issue I wanted to mention before moving to family is that, let's say your non-immigrant status is expiring and you are not intending to renew that. And one question that we get a lot is, does filing the immigrant petition, the I-140, extend your status? And the answer to that question is no. Just filing the I-140 does not give the individual any extended status to stay in the United States. However, if you are able to file the I-485, then you are able to remain in the United States while the application is pending. So for questions like this, definitely also reach out to us and we can help you figure out the best strategy here. Now, then for the last consideration, let's talk a little bit about family. The EB-1A and EB-2 NIW are both employment-based green cards and allows spouses and minor children to obtain green cards also as derivative beneficiaries. So if you have children who are under 21 and unmarried, and if they're close to being aging out of that benefit, perhaps that is another timing consideration you might want to have. You may want to apply for the green card early so that your children can benefit from this system. All right. So then the last topic that we'll cover before we get to the Q&As is, are extraordinary ability categories available for entrepreneurs? And the answer to that question is yes. So both for the EB-1A and EB-2 NIW, as I mentioned earlier in the presentation, they both allow for self-petitioning, which can be a great option for entrepreneurs who may have difficulty getting a U.S. Employer sponsor to sponsor them, as you know, many of entrepreneurs are self-employed. There has been changes in the National Interest Waiver NIW standard under the new case law matter of Danisar, which made the evaluation a little bit more friendlier and favorable for entrepreneurs. The types of evidence that they're going to consider now has expanded to, include entrepreneur specific criteria such as ownership in a company, admission to an accelerator, or being approved for a venture capital funding, for example. All of those entrepreneur-specific evidences can now be used in EB-2 NIW petitions to support various aspects of your case. Also, let's talk about the O-1A option, for example. If you are an entrepreneur active in the field of business, and if you can meet the criteria for having obtained substantial national and or international acclaim, you can certainly also use a U.S. corporate entity that you own as the vehicle to support your O-1A visa application. So it is completely fine to own an entity that you are being sponsored for. And by sponsored, I mean that the entity would act as the petitioner driving the petition. That is certainly an option that you can consider. So this also can expand the availability of this option for entrepreneurs. All right, so then let's see if we have any questions that came in. Not seeing any.
No, doesn't look like we do. So I think we can close here. So thank you, everyone. And I hope you have a wonderful day.
Thank you.